Hello, my name is Sarah Coderre, and I am a human rights, employment, and labor law lawyer in Calgary, Alberta with Bow River Law. Today I'm going to answer the question, can I use my invention if I got dismissed? Whether or not you can use your invention that you developed presumably while you were employed is going to depend on what policies and agreements you made with your employer while you were still employed. Some companies will have an employee sign off on intellectual property agreements in the event that there is technological know-how that may be developed or inventions that could be developed in the course of their employment. Other times, companies will have very strict confidentiality agreements that employees are required to sign, which means that anything that gets developed during the course of that employee's work with the employer is protected and is considered to be confidential and proprietary information by an employer. If you've signed off on an agreement like that, chances are you probably can't use your invention if you got dismissed. Those agreements are going to be binding on you regardless of who chooses to end the employment relationship. And if you're unsure, it certainly is something you should discuss with an employment lawyer. However, in many cases, especially with smaller companies, you may not have signed anything. You may not have signed an intellectual property agreement or a confidentiality agreement, and you may be wondering, is this something that you can use? Generally speaking, whether or not an invention that's not otherwise governed under any sort of written agreement can be used when an employee leaves their employment is going to depend on a couple of factors. First of all, when was the invention developed? If the invention was developed by the employee on their own time, without using any of the employer's resources, and simply the idea maybe came to them as a result of something they were working on for the employer or just randomly, then likely you could use that invention after you've been terminated from your employment. However, if you develop the invention on your lunch break or off the side of your desk during some boring meetings at work, if you were using the employer's tools or using any of their own existing technology or proprietary information to develop this invention, then the question is a little bit more nuanced. And potentially, there might be some joint ownership of that invention, or in fact, it might be wholly owned by the employer. If you are concerned about whether or not something you feel you've developed and that you feel you rightly own is yours following the end of your employment, you should absolutely reach out to speak with an employment lawyer and understand what rights and entitlements you may have to that invention depending on your circumstances. This is a highly fact-specific exercise to determine ownership. And in fact, in addition to an employment lawyer, an intellectual property lawyer may also be needed to understand what the invention is, what types of legal protections could be drawn to it, whether it's trademark or patent laws, and then to assist you in protecting it going forward if in fact it is yours. If you are considering whether or not you should develop something while you still work somewhere, it's always very important to remember that ownership of something can potentially be contested if it's viewed as being valuable. If it's worth fighting over, the employer may try to fight you over it. And the steps that you take while you're developing that invention to make it very clear that it is something that belongs solely to you, taking those proper steps in advance can help to save you a world of hurt and pain in the future. So specifically, you would want to make sure that if you are developing something that's not related to your work, that you are doing it during your own time. You were doing it with your own resources, meaning don't use the company computer on your lunch break to do it. Don't use the company laptop to do it at home on the weekends. Use your own technology, use your own resources, use your own time to do so. In some cases, especially at tech companies, an employer may permit and understand that employees will develop other inventions and devices during the course of their employment, but the employer wants to be kept in the loop about what is being developed, and presumably that's so that the employer can either understand whether or not this is something with value that they might want to purchase from the employee, or just to make sure that there's a really clear line between what is the employer's property and what belongs to the employee. And so having awareness about the policies in your workplace, the agreements you might have signed, and being able to reach out to an employment lawyer if you have any questions is going to be essential to understanding your rights and protecting your ability to use any sort of invention you might have developed in the future. Thank you.